Appeals Division 1 is now in session.
Please be seated. Morning. This is the time set for argument in the case of Villa versus Führer, our civil number 13-0653. Each side will have 20 minutes within which to present their arguments here this morning. Appellant may reserve some portion of that 20 minutes for rebuttal. At your discretion, it's up to you, however, to keep track of your time in that regard. We have read the briefs. We've been through the record. We've conferenced the case this morning, so we're familiar with the issues that have been raised, and so keep that in mind, please, as you make your arguments here this morning. We are recording the proceedings, both by audio and video, and the video will be available on the internet within a matter of a few weeks after the argument, in case you want to see what it looked like. With that, Mr. Gantz, you may proceed.
If it may please the court, my name is Adam Gantz. I represent the appellants on this appeal and the plaintiffs I was trial counsel for in the underlying matter. I'd like to reserve 5 minutes of my time for rebuttal. Thank you. The issues presented in this case call into question the integrity of our trial system at its absolute core. Specifically, how far is too far that a civil attorney can go in making and polluting a trial with extraneous information in order to advocate for their clients.
Mr. Gantz, I hesitate to interrupt, but it seems to me that the main argument you're making here, and you're about to make to us, is that individually and more importantly, cumulatively, these alleged instances of misconduct created a prejudicial effect for your clients, and we should do something about that. I got that right?
Yes.
I guess I'm curious as to why these issues were not brought to the trial court's attention by way of a motion for a new trial, or perhaps more to the point, a motion for mistrial, thus giving the trial court the opportunity to consider the cumulative effect of these instances.
Well, there are several reasons. First of all, I felt that the record was well preserved. There was multiple instances where I had made several objections to these comments, to these actions, to this evidence, and inadmissible evidence coming in. I made several bench conferences that were had. In addition, some of those objections were overruled. Not all of them were upheld, but some of them were overruled. By doing that and the cumulative effect of all that, I felt as though the record was preserved well enough. The question is, why didn't I file a motion for new trial with the judge and allow the judge to make that determination? And the reason is because I did not believe, after review of the jurisprudence with regards to attorney misconduct, that the cumulative effect of an attorney's conduct is well outlined in the jurisprudence. And I felt as if the trial court would not have a good basis for what to apply for the cumulative effect. Certainly, there is jurisprudence with regards to individual instances of misconduct, and there's certainly plenty of case law out there that in a wide spectrum. But there was not a specific case that talked about what happens when it's so prevalent within a case that it causes an unfair trial. And at that point in time, it was a decision to file with your honors, because I felt as if that issue needed to be addressed, and the standard for attorney misconduct that is cumulative needed to be addressed. I don't believe that no matter what happened with the trial court that we would still be here today anyway, and I felt for judicial economy to move this along that it'd be best to do that first, and that's what the decision was.
But generally speaking, wouldn't you agree that the trial judge, who's in the courtroom having presided over the case for a number of days, and having had the opportunity to observe the complained of conduct, observe the jury, is in a better position than this court to appreciate the significance of that?
Well, certainly, Your Honor, I understand that. However, when you're talking about attorney misconduct, there's clear case law out there, for instance, in Tucker, where objections are overruled, and it was deemed that if the conduct was so prejudicial, that can be determined by an appellate court. There's other cases out there, like in Sisk, that they did not seek a motion for new trial at the time of the trial, and the appellate court deemed to be necessary for a new trial in order to obtain a fair trial for the litigants. There's multiple cases out there. Even in Tanner, I believe, there was discussion about whether or not a trial court, it's more of a, to be honest, Judge, it's more of a form over substance at that point in time. Yes, can he outline some of the issues? Can he, but we felt that the record was clear. There was multiple instances where we had made these objections. We had asked the judge for conferences, where he'd asked the judge in some instances for curative instructions on certain issues. For instance, on the Dr. Merrick issue, where he's talking about payday, and he's talking about a clear motion in limine that says Dr. Merrick cannot talk about the fact that these doctors are profiting. Clearly prejudicial. There's a motion in limine on it. We had a bench conference right before this testimony, and it was discussed, and Dr. Merrick was admonished. And at that point in time, he still went through. He makes a comment that they're out there. We're here in this court just for one reason, and we all know why. I made an objection. It was overruled. I moved to strike, and it was overruled. The point, Judge, is that it was so prevalent throughout this trial, the record was clear on all these issues, that I felt like it could be brought before Your Honors and determine whether or not it was the cumulative effect of that, which, again, I do not believe there's a specific case out there, and if there is, and I'm mistaken about that, and if Your Honors want me to address that, I will try, but I didn't see a single case out there that talked about a cumulative effect of multiple misconduct in both areas of attorney misconduct as well as juror misconduct. Obviously, the two issues are totally separate. We're just focusing on the attorney misconduct. And when you have a situation where, for instance, on the traffic accident report, the jurisprudence for 40 years has been that inadmissible hearsay is rank hearsay and reversible error. Yet, Ms. Kurchanski gets up and asks questions specific about that. We have bench conferences after I am forced in front of the jury to rightfully object to a point that should never have been brought up in the first place. Now I'm in a position where I'm actually defending myself. My clients and I are both looking like we're now trying to hide information from the jury, which of course is their ultimate purpose is to ascertain the truth. And she's putting me in a position on something that is clearly not coming in, that clearly shouldn't have been asked, and we have a bench conference on that. She's admonished about that, and then she continues with the next witness and asks about speeds. Of course, there's no accident reconstructionist, there's no biomechanic, there's no basis whatsoever for these questions, yet they're asked anyway to pollute the jury and to prey on their prejudice with regards to plaintiffs who file personal injury cases. And that's what this case did. She went and she wanted to try a system case. This wasn't about my clients. This wasn't about me. This was about people coming into her community, as she called it, and filing a claim and trying to make this more about a system case, preying on the jurors' prejudice with regards to filing claims and all the frivolous lawsuits that are out there and that are in jurors' minds. Yes, sir.
Yeah, I appreciate your passion.
Sorry,
this
Judge.
Morning. I wanted to ask another maybe housekeeping question, because you referenced the juror misconduct issue, and perhaps you're going to get to that later in your argument. But I noticed from the record that at one point the court brought each of the jurors into chambers with counsel and interviewed them. But there was no record made of that, correct?
That's my best recollection. I actually remember being a court reporter or somebody taking notes there. We went back and looked at the record, and there wasn't one. We also went back into court minutes, and there's nothing specific about it as well. I have some memories of that. Obviously, that would be inappropriate for me to talk about. But the reality and the ultimate outcome is telling on what that issue was. This judge determined that there was misconduct, and therefore he excused this juror. Now, it was a little late, and that was our whole argument.
Well, maybe I misunderstood the record that I did look at.
Okay.
And maybe this inference is not the correct one to draw, and you can comment on that, but it seemed to me that the court invited counsel to fashion a remedy, which was to have this juror serve as the alternate, and that the parties agreed to that. If I mischaracterize that?
No, you didn't mischaracterize that. However, for 5 days, both Ms. Kurchansky and I had told the judge that this juror needs to go. We had grave concerns about the fact that this person who is her partner, who he drove with her, who was in our courtroom for almost, I believe it was a full day, before anybody recognized that he was actually a part of, knew any one of the jurors. He was in the courtroom. He knew these things. He heard outside the presence arguments. And at that point in time, we had started bringing concerns. He was out there talking to witnesses. Even after he was admonished, he was out there talking to witnesses, also making comments with regards to attorneys in passing. Those types of things were concerning. We kept on bringing these things up. And we wanted the juror gone. We actually asked, hey, this juror needs to go. We got extras. Go ahead and kick her off the jury before they start deliberating.
Counsel, to follow up on Judge Winthrop's question, the juror was let go.
Yes.
It's just, but now on appeal, you're arguing, even though that was by agreement of the parties, it was too late.
Yes, Judge, that's correct. It was too late. It was on day 6. It was already after closing arguments at that point in time.
Right.
She actually stayed even after it was determined that she wasn't going to deliberate, and he determined that she wasn't appropriate to deliberate, that she actually stayed through closing arguments and then went ahead and she was deemed to be an alternate and dismissed.
All without objection.
Well, it wasn't quite without objection, Judge. I had made my objections for 5 days, and at that point,
Did you move to preclude the juror earlier?
Yes.
I understood the record as saying that you agreed with the process that was followed, and I struggle with finding why that wouldn't be waiver at this point.
and I appreciate that, Judge. For 5 days, Ms. Kurchansky and I told the judge that this juror needs to be dismissed from day one.
Understand.
From day one.
And the juror was dismissed.
Not until afterwards. We were asking early on. We were asking before they can do interim deliberations pursuant to Arizona Rule 39F, that they could not deliberate during this period of time with a juror that shouldn't be deliberating with them. And we asked that from day one. The judge denied that request on multiple occasions and finally fashioned this idea of making an alternate. And we said, okay, I guess if that's the best we're going to get, we'll go ahead and get that. There wasn't much more we could do about that at that point.
So she's made an alternate. She's made an alternate.
Well, I think the record's actually confusing. I didn't mean to cut you off, Judge. I'm sorry.
Go ahead.
I think the record's a little confusing on that. He actually dismissed her as an alternate, which didn't make much sense because he actually determined her to be an alternate, but yet essentially fashioned a way for her not to feel like she was being dismissed.
Right, which happens not infrequently.
I'm sure it doesn't.
So how are you prejudiced? I mean, she's not deliberating with the jury.
For 5 days, she deliberated with the jury.
But is there any evidence, is there any record that anything that she learned from her partner was communicated to the juror, to the other jurors?
Nothing in the record, Judge. However, I can tell you that when the judge determined that she had committed misconduct, I think the burden then shifts to the defense to show that it was not prejudicial. And that's what I believe the Poland case talks about. Specifically says that once the misconduct is determined, then it's now the burden to show that it wasn't prejudicial, that she did receive outside information.
Mr. Gans, is there a judicial finding in the record that this juror engaged in some form of misconduct? I don't remember seeing that. I know that's your conclusion. You were there. That's the inference you drew from matters outside the record. But there's no judicial determination of misconduct, is there?
If he had not found that, he would not have dismissed her as an alternate.
Why do you say
and there's
that?
no other explanation for that.
Well, or is there?
Okay.
I mean, couldn't it be, look, the parties have concerns about this juror, and a way through this is to designate this juror as an alternate, but still do a random draw that just doesn't include that person. Isn't that another way to explain this?
Well, not exactly, Judge, because there was 5 days of deliberations already. And at that point in time, it was determined that...
I think you're answering a somewhat different question than what I was asking.
I'm sorry,
Was
Judge.
to
I don't mean
follow
to
up
evade you.
on Judge Winthrop's question about what determination is there that there was misconduct by this juror.
I don't believe the record shows that there was prejudice. It doesn't show the specific information. The record does not show the information. However, implicit in his decision there is only one alternative, that he determined there was enough information that there was misconduct. Otherwise, he would have said no like he did for 5 days.
Well, but I just posited another alternative,
Okay.
and I'd be delighted to hear more about your reaction to that.
Well, I don't believe, and again, I'm speaking with forked tongue because I can't share with you what we found out in that conference and from what my memory was, and there was no record of that. And that I can't add anything more to it, Judge, than that, other than to say that his ultimate action speaks volumes. I don't know how else to address something that's not in the record that I can't make up. I can't provide that information to you, and I don't feel comfortable doing that, knowing that it's not part of the record.
And just to then follow up on what Judge Kessler was asking, we don't know how or if the jurors were affected by anything juror number 10's companion did or didn't do. Is that fair?
Yes. However, you don't know that. That's correct. However, again, from the judge's determination that there was misconduct, if we assume that that's the reason why he did what he did, then the burden then shifts to them to show that it did not prejudice this particular jury when they had outside information. And now they're hampered by the fact that there's no record on that particular issue. And the reality is that both parties were concerned about that type of problem for days. And it wasn't the issue of what to do on day 6, it was what to do on day 1. And then day 2, 3, 4, 5, and that was the ultimate issue. And my time is up. If there's any other questions, I'll be glad to take them now, and then I'll still reserve less time later.
Oh, no, that's fine. Mr. Gantz, thank you.
Thank you.
Good morning, Your Honors. The minute entry that was filed April 12, 2013. This is what it says: a record of the proceedings, and this is the proceedings in chambers, is made by audio and or video tape in lieu of a court reporter. There would have been a record, but the truth is the parties had been working in conjunction with the judge throughout trial. It was a difficult situation because the one juror's companion was in the courtroom at times maybe that were inappropriate. They stipulated all the way along, this is what we're going to do. At the end, they said, we'll stipulate that that juror will be an alternate. We don't want to, antagonize the jury in any way, so we'll make sure that it's secret. The juror is designated as an alternate. That's the end of it. We have no idea what, if anything, that juror said to any other jurors. It's 100% speculation. She might have been in there saying, these plaintiffs deserve millions. She might have been in there saying, we should throw these two out of the court. She might have said nothing at all. Nobody will ever know. And it's their burden to show not only that there was extraneous prejudicial information introduced to the jury, but also that it was prejudicial. There's nothing. They cannot even identify what this juror said. Your Honors, this is a case, as you've read the briefs, it almost sounds like two different cases. Because we set forth the evidence that supports the jury's verdict, the overwhelming evidence that supports the jury's verdict, and they have complaints about the ultimate verdicts. They have complaints about defense counsel. They have defense about the jurors. Implicitly, they have complaints about the trial court. Those are all complaints that every case out there that I can find says you first have to take to the trial judge. The trial judge is there. The trial judge has seen everything. The trial judge has heard everything. The trial judge knows the history of the case. The trial judge knows what's happening in the heat of the trial. The trial judge and opposing counsel first have to be given an opportunity to correct any defects or errors before they can come to this court. And we cited the Supreme Court case of Trantor. The Miller v. Palmer case makes that crystal clear. You may not always have to do everything. You may not have to object and file a motion for mistrial and file a motion for new trial or ask for curative instructions. You may not have to do everything, but you have to do something. You have to do something to give that trial judge an opportunity, and they didn't. They made some objections, and Judge Ray ruled on those objections. Sometimes he sustained them, sometimes he overruled them. At least once they asked for a curative instruction, he gave a curative instruction. At least once they asked the judge to admonish Dr. Merrick, the defense expert, so the judge looked down and said, "Dr. Merrick, you're admonished." There was never a motion for mistrial, and there was never a motion for new trial. At least on the issues of attorney misconduct and juror misconduct, which are fact specific. It's the evidence is there. If there was any evidence, it's there. The trial judge has seen it, heard it. It is a question of sufficiency of the evidence, and 12-2101C says that if you're ever challenging the sufficiency of the evidence to support a jury's verdict, you have to file a motion for new trial.
Mr. Robbins,
Yes.
Mr. Gantz was arguing to us a few minutes ago and said that under these circumstances where the court has had sufficient concern to have brought each of the jurors into chambers for an individual interview to try and evaluate an inference here of misconduct, trying to evaluate whether that misconduct has had an impermissible effect on the existing jurors. His argument is that the burden of coming forward then with evidence shifts to the defense. So I'm interested in your thoughts about that.
Absolutely 100% not, Your Honor. If Judge Ray had found that this juror had engaged in misconduct, that would have been it. He would have dismissed her right then. She would have been gone. He would have ordered her out of the court. There is no finding on the record. The logical implication here is, if you want to make inferences, the logical inference is that the judge didn't find any misconduct, but he, like the party's attorneys, was concerned, and so they worked out a solution. And the solution was, we're going to designate her as an alternate. We're not going to trouble the rest of the jury. We're not going to do anything else. It's just that when we draw those numbers at the end, one of those numbers is going to be juror number 10. And she will not deliberate. She did not deliberate in this case. We have no idea what she ever said to any other juror, if anything. We have no idea if it had any effect on any of the other jurors. And it certainly doesn't overcome the overwhelming weight of the evidence in support of the jury's verdicts in this case.
Well, my guess is that in this case, the jurors at the beginning of the case received a standard instruction that they could not only ask questions during the trial, but they could discuss the case among themselves if they all agreed.
Yes.
Is there any evidence in the record that the jurors did in fact deliberate together about the case before juror number 10 was designated as an alternate?
None whatsoever, Your Honor. And once again, it's entirely speculation. She might have been gung-ho for the plaintiffs. She might have been saying, we ought to, slam my client. Maybe we should give them millions of dollars. But there's no evidence. There's no evidence anywhere. It's just entirely 100% speculation.
I don't want to interrupt your argument, but I'm interested in your perspective on the Rule 68 offer of judgment arguments that
Well,
parents have made here.
Yes, Your Honor. I've never had a situation happen where it seemed that two cases came out at exactly the right moment in support of our position. One is the Boyle case talking about their waiver of any objections because they didn't do it within 10 days. That's Rule 68D. It just seems to me that that's, again, we're talking about waiver again, but they've waived the Rule 68 arguments. Their big concern was liens, and the Cuellar case came out at almost exactly the same time, saying when you compare the offer of judgment to the judgment finally obtained, which is what the rule requires, you don't consider medical liens. There's no way that you could ever consider medical liens in that. And the idea that that somehow they came out better. They came out better than the offers of judgment. Ms. Villa was offered $10,600 very, very early on. Mr. Alamillo was offered $16,200 very, very early on. If they had accepted those offers, they would have had that money in their pocket. They could have done whatever they wanted to do with it, including reducing their outstanding liens. They rejected that offer, and so instead of having, almost $27,000 in their pockets, they now owe $50,000, and their medical liens that they incurred for their own medical treatment are all still out there. Nothing has changed.
Well, the offers of judgment were conditioned on obtaining lien releases or agreement by the lien holders, weren't they?
It said something to the fact, yes, that this includes satisfying liens, and the Cuellar case answers that too. He says, of course a defendant wants to protect himself from medical liens, because 33-934 says that the lien holder can sue not only the tortfeasor who incurred the medical liens, but also not only the person, the patient who incurred the fees, but also the tortfeasor and the tortfeasor's insurance company. So Cuellar, again, I believe, answered that question. It said, of course they want to try to protect themselves. And I will tell you quite frankly that if it sounds more like a contractual matter, and if they had accepted the offers of judgment, Daniel Ferrara was not going to come back and sue them for breach of contract or something. I'm not even quite sure, how that happens. But, those cases came out at exactly, in fact, I believe it was right after I had filed the answering brief, or we had filed the answering brief, and it seemed to me to answer both questions. The other objection they had was to the reasonableness of the expert fees. Well, that's the flood control case, the levy case. They both say it's entirely in the discretion of the trial court judge to determine what's a reasonable expert fee, what the expert needed in preparation for trial, and also testimony at trial. Judge Ray exercised his sound discretion in that matter. Their last issue was costs. Judge Ray exercised his sound discretion after they filed for $54,000 in costs. In making claims that Judge Ray said, this almost sounds like a violation of Rule 11, Judge Ray awarded them awarded her $3,000. She was the only prevailing plaintiff. Awarded her $3,000. And again, everything was the amount was in his sound discretion. That's the Fowler case that we cited.
Can I go back to the
Sure.
The first argument Mr. Gans made, was he was talking about the efforts by defense counsel in examination and cross-examination of witnesses, and using sounds what he characterized what sounds like information in a police report, which is otherwise inadmissible, as the basis for that examination or cross-examination. Is that something that we should be concerned about? Is it something we should condone? I mean, his point, I believe, is that the report is never going to come in to evidence. It is full of hearsay information that's otherwise inadmissible. Yet defense counsel is using that report as a basis to cross-examine the witness.
Well, Your Honor, Judge Ray obviously had the same concerns because he precluded the report. In addition, he instructed the jury that the police report does not come into the record. Should you be concerned? Quite frankly, no. I don't see. I read and reread. I've obviously read and reread all of the complaints that he has, and they're inconsequential. They're not significant. They're not substantial. You look at some of the things that happened in some other cases, Grant versus UPS. Here's a very, very prominent attorney basically lying about what's said on one of the exhibits, and the Supreme Court said, well, you know, that's not conduct that we approve of, but it's not prejudicial, didn't cause it's not merit a new trial. There's what they've complained about are just sort of the back and forth that happens at any trial. The case law all says that attorneys are given broad discretion, liberal discretion in cross-examination and in closing argument. If there was anything wrong here, Judge Ray corrected it. Often it went unobjected to. When it was objected to, he either sustained the objection or he denied the objections. This is nothing here that was substantial. And then the second step, nothing that was prejudicial, because the weight of the evidence was it was not only substantial, which is all the case law requires, but it was so overwhelmingly in favor of the jury's verdict that nothing here would have made any difference.
Do I understand your argument, though, correctly, particularly with respect to police officers' report? Your argument is largely focusing on lack of prejudice. I mean, there were things that happened with that report that seems to me, looking at the cold record, should not have happened. There were objections that were sustained. There were limiting instructions. I mean, there were lines that were crossed. But do I hear you right in saying that the Superior Court then properly handled it when those were crossed?
Oh, absolutely, Your Honor. And it's entirely irrelevant, which is what the judge and the plaintiffs were saying all along, because the only issues here were the reasonableness and necessity of their medical treatment and whether it was caused by this accident. Liability was not at issue. We admitted liability. Our client admitted liability. He said, yes, I was coming up on the ramp in rush hour traffic. I thought I was going to be able to move over to the next lane. I clipped the back of their van, and I'm at fault. But then when the parties in the minivan, they walk away from it. They don't make any complaints to anybody. They don't seek any medical treatment. In fact, they don't seek any medical treatment until a week later when they're back home in Las Vegas. It was just, I think one of the things that might have prompted it was that at some point, Mr. Alamia said something like, oh, I heard somebody say that Daniel Farrar was going at 55 miles an hour, this was rush hour traffic, Your Honors. Nobody's going at 55 miles an hour in rush hour traffic. He was merging onto the freeway and as I said, thought he could move over into another lane, and he couldn't quite make it. I know they have lots and lots of complaints. Is there any other particular complaint. That, let me just conclude, Your Honors, and unless you have other questions, we just ask you to affirm the judgments as to both plaintiffs.
Thank you.
Thank you, Your Honors.
That's a perfectly good example of what happened there. He tells you that it's not important, it's not relevant. So why is she asking these questions? Why is she going through not only in the first witness of the case, but the parties, both parties, and continuing to talk about this stuff? Why is she doing that? She's doing it because it's improper, she knows it, and she's doing it deliberately to poison the jury. And that's just one of the issues. There's 8 that we've talked about. There are 8 particular issues. And by the way, the Taylor court held that remarks and conduct cannot be cured by objections and admonishments. The traffic accident issue was the only one that was actually had an admonishment with it. The rest were overruled and or allowed anyway. More specifically, I'll give you another example. Dr. Merrick talking about the fact that he did surgery on somebody from her office. Why is she bringing this issue up? It doesn't go towards his credibility as a witness. It doesn't go towards his expertise. It goes towards her personal belief that he's a good doctor. To get in front of that jury and say, hey, look, we believe this guy's a good doctor, that's unethical. She asked those questions on purpose. That's just another example. Again, the payday arguments that Dr. Merrick got into.
Counsel, let me ask you, you had mentioned in your opening presentation if I heard you right, sort of a gap of case law or lack of case law dealing with what you are arguing is sort of the cumulative effect of what you claim is attorney misconduct in front of a jury. Does that gap still exist? Are you aware of any cases that acknowledge or recognize that concept?
In Arizona?
Yes.
I do not believe there are any binding cases in Arizona that talk about rampant, multiple effects of intentional and deliberate misconduct. There are several that talk about single instances, and it goes back and forth, and the yes, Your Honor.
No, I understand the single instance,
Yes.
but sort of the however you want to phrase it, but sort of the cumulative effect.
I do not believe there are, and I believe that this is a great opportunity for Your Honors to define the jurisprudence in that area, so that we have an idea. And the reason you want to do that is because some of the cases talk about, I think it was the Tanner case, had talked about the fact that you'll defer to trial court's rulings on the misconduct unless it's clearly prejudicial. And in the Tanner case, what they said was, we cannot continue to promote this type of conduct by attorneys and by affirming these types of actions. And when it's multiple and cumulative, as it is in this case, the message that you're sending is, hey, look, I can walk into a jury trial and say, hey, look, insurance, this defendant's got insurance. The judge can give a curative instruction and said, okay, it's all right, you can talk about, you can't think about insurance. But once that bell is rung, it's over. There's nothing we can do about that. Now, what is the difference between talking about the doctors doing surgeries for money as opposed to going towards their actual procedures, going towards the actual medicine? Yes, sir.
Is your Tanner your best case on the issue that you didn't have to file a motion for a mistrial or a motion for a new trial based on attorney misconduct?
I do believe Sisk versus Ball, 91 Arizona 239 in 1962, also did not file a motion for new trial.
Okay, so those are your best
I
cases.
also believe Tucker talked about where an objection is overruled, the objection need not be repeated and repeated and repeated. And I think that's the same concept, although a little bit deviated from what you asked.
And then your argument about the burden of proof on juror assuming there's an implied finding of juror misconduct, the burden of proof then shifts to the other side to show that it wasn't prejudicial.
The Poland court said that the Poland court, State versus Poland 132 Arizona,
Okay.
269, said in cases of outside information presented to the jury, there should be a new trial unless it can be concluded beyond a reasonable doubt that the extrinsic evidence did not contribute to the verdict. And then Kirby versus Roswell applies that to a civil matter in this division in 1982 applied that to a civil proceeding as opposed to a criminal proceeding.
But we don't know what, if any, extraneous outside material was presented to the jury.
All we do know, yes. I do believe, however, the judge's actions tell you that something was going wrong and it had gone wrong for 5 days. Again, if you look at the cumulative effect of the 8 juror misconduct issues, you'll see that my client was deprived the ability for a fair trial. I'm out of time. I didn't know if you wanted me to address the 68. I didn't get it.
We have your brief.
Thank you.
Thank you.
I think it's well
Counsel.
briefed. Thank you, Your Honors.
Thank both counsel for their arguments here this morning. We're going to take this matter under advisement. We will issue our written decision in due course, and we are adjourned. Thank you.